remote session this morning due to the pandemic and allowing everyone to be present. May I please reserve 5 minutes of my time for rebuttal?
Okay.
Your Honors, an injustice has occurred, we submit. Disabled state employees who have worked for the state for many years and were vested members of the state's retirement and disability benefit system had their disability benefits improperly withheld. And now their claims have been dismissed on a Rule 12 motion, which was in clear error by the trial judge who did not take the factual allegations in plaintiff's complaint to be true for purposes of a Rule 12 motion, which the trial court was required to do. Now, I'd like to, Your Honor, start with a brief factual and procedural history to explain how we got to this point before you today. Debbie Moss is one of our clients, one of the petitioners and plaintiffs. She was a teacher, school teacher, Wake County Public Schools. She was injured in an automobile accident in 1990 and was unable to continue working, became disabled. She was a vested member of the state disability benefit and retirement system, and she had contractual rights to receive disability benefits at the time she stopped working due to her disability. Carla Shuford, she worked for UNC Chapel Hill as an administrative employee. She lived her life since childhood with one leg, with a leg amputation from osteogenic sarcoma and a tumor in her leg. And even with that condition, she was able to work for UNC for many years, but became medically disabled after a breakdown related to her disability and illness in 1988. And at the time she stopped working, she was a vested member of the state's disability benefit system, and she also had contractual rights to receive her benefits under the teaser system. Now, both Ms. Shuford and Ms. Moss received disability benefits from the state for decades. And both of them, they're not wealthy people, Your Honors. They rely on these benefits to live, to meet basic life needs, to pay for shelter, medicine that they need, food, other basic things that they need. This is part of their required living income. And the state, what brings us here today is the state made an error, and it admits that they made an error in the calculation of the amount of disability benefits that it paid to Ms. Moss and Ms. Shuford. And the state admits that this error was not caused in any way by Ms. Moss or Ms. Shuford. It was their mistake, and it was an overpayment over the course of decades, of a very long period of time. And then out of the blue, in 2017, the state notified Ms. Moss and Ms. Shuford that because of its own error, it was now going to be making a very significant reduction in the amount of their monthly benefits. So now they'd be in a position where they wouldn't have the amount of money each month that they needed to pay for the things that they need in their life needs. And that it was going to be, from now on, clawing back this amount that it claimed was overpaid going forward. Now, we contend, and we have alleged in our complaint, that this withholding of benefits by the state constitutes a breach of contract, as Ms. Moss and Ms. Shuford have contractual rights to receive their full benefits without reduction for errors made by the state a decade earlier. And we contend this and have alleged it also amounts to a breach of the implied covenant of good faith and fair dealing, and in the alternative, a claim for violation under the North Carolina Constitution, also called a quorum claim, based on the seminal case of Quorum versus University of North Carolina, recognizing claims directly against the state when there's no other type of claim available, no other type of adequate state remedy available. So,
excuse me.
Those are the yes, Your Honor.
Didn't they agree years ago in writing that if they were ever overpaid, that the state could claw it back?
Your Honor, I wouldn't say that was the case. I'm not sure if you're referring to a particular document, but that's not my understanding that they knew or agreed to that. And as a vested recipient, it's our position that, and this is supported by the Falconberry case that we cited to in our brief, that they were entitled to receive benefits at the level to which they were receiving them at the time their rights became vested.
Well, it looks like in the record that each signed a statement when they were approved for benefits, that it says, if I am overpaid benefits by the disability income plan, I will reimburse the plan when advised. So that sounds to me like they've agreed to the clawback. Is that not, do you not agree with that?
Your Honor, no, we respectfully don't think that they agreed to that, even if there is a paper to the contrary. I understand you're citing to a document in the record, but we have alleged claims that there was a contractual obligation and then there was a breach of that for not paying the full benefits that were owed. And our allegations need to be treated as true for purposes.
The contract to which you refer?
Excuse me, sir?
Mr. Taylor, isn't the fallback provision that Judge Zachary has pointed out to you in the record, isn't that part of the contract that you're alleging has been breached?
Well, it's our allegation that they had the right to not only receive the amount of benefits that they were entitled to at the time that they vested, but also receive fair treatment in terms of having due process, both procedural and substantive, by not having benefits withheld from them in this way, going back for 20 years. And I don't think that they ever knew or agreed that the state could, 10 years ago, have its own calculation error and then today come and say, we're going to be withholding your benefits now because of that error that we made 10 years ago. That wasn't contemplated by them.
So the calculation error, as I understand it, resulted in overpayment of benefits. Is there a disagreement as to that point?
We agree that there was an overpayment of benefits. We disagree as to the amount of overpayment of benefits, but there was an overpayment of benefits, and the amount that the state claimed what it had overpaid was very incorrect based on the actual records from bank statements and showing how much the calculation should have been that was established at the OAH proceeding. But yes, we do agree there was an overpayment, although not in the amounts claimed by the state.
So if there's an overpayment of benefits, and the position that your clients are taking now is that their benefits some years later should not have been reduced to recoup those, statute requires the state to attempt to recoup those benefits through that. Well,
Your Honor, we would respectfully contend that the statute also requires that the state, that people be treated with fairness and with due process, and not be, I mean, we're talking about decades into the past where overpayments were made through no fault of these disabled state servants who worked for many years and need these benefits.
Taylor, the overpayment was payment of monies that I think we are of the position that they weren't entitled to at the time. So to not let the state recoup that would result in a windfall for Ms. Moss and Ms. Shuford.
Well, that's not the way I would characterize it, but there was an overpayment, Your Honor. It is correct. There was an overpayment. The amount that the state claimed that it had overpaid was not a correct amount. And we would respectfully submit that the state should have the correct amount before it withholds people's disability benefits, and it should provide them with notice and an opportunity to contest withholding of their benefits that they need, and it should treat them with fundamental fairness, which is guaranteed by the substantive due process rights of our state.
Mr. Taylor, wasn't the overpayment due to the Social Security benefits or money that they were receiving at the time? There was a difference in the amount of the percentage that was actually calculated for the reduction. Is that correct?
Yes, that's correct. They actually had a very simple formula, Judge Wood, where they would just take, they had a total amount of benefit, disability benefit for state and federal combined, that was supposed to be paid to a person such as Ms. Moss or Ms. Shupert. And then you needed to have the federal benefit was reduced from that total, and what was left over was the amount of the state benefit, and that's how much should have been paid. And so what we did in the OAH proceeding, which was, by the way, limited to only was the calculation correct or not. They did not address whether there had been a breach of contract or whether there was a violation of the Constitution. It was just, were the numbers mathematically correct or not, which is why the doctrine of collateral estoppel doesn't apply, which I'll explain in a minute. But yes, there was a formula, Your Honor, based on how much is the total benefit, state and federal combined. You subtract the federal benefit, and the remaining amount is what the state should pay as its benefit. And for Ms. Shupert, we presented evidence showing how much she had actually received in federal benefits, and it was very different from the state's spreadsheets and calculations, showing that there was approximately $15,000 to $14,000 that the state was off by. It was trying to recoup over $14,000 more than it was entitled to recoup, even under its own theory, which we would disagree with, but even under its own, under that math was incorrect math. Does that address your question, Your Honor?
Thank you.
Okay, thank you.
Did you introduce evidence, though, of net benefits rather than gross benefits?
Your Honor, we presented what the state stated in its testimony would be the correct amount, or would be the variable that was required. I mean, the state did not testify that it would be an incorrect statement to put on the evidence that we did, which is looking at the actual benefits received by Ms. Shupert and then subtract that from the total amount of benefit that they had calculated, and that should equal the amount that the state was required to pay. And the state's own, I forget the name of his or his position, but the state's, Mr. Thomas Causey is his name, his agent, the person working for the retirement system who did these calculations, admitted that's the way they needed to be done to reach the correct total. But that wasn't the way that they were done in this case.
How do you respond to the division's argument that the plaintiff's contractual rights consist of what the statutes provide?
Well, Your Honor, we believe that the statute was amended after the time their contractual rights vested, and their contractual rights were set at that point when they vested as recipients. And that's set out by the Falconberry case. It says that a recipient of the State Employee Retirement System's benefits has a contractual right and then can also bring a cause of action for breach of contract if those rights are violated. And it's based on rights at the time that they vest.
Thank you.
Your Honor, so I've described the claims that we brought, and I also want to just highlight with the quorum claim, as I mentioned, that was pled in the alternative. And so even if there was not a claim for breach of contract or breach of the covenant of good faith and fair dealing, there would still be a claim under the North Carolina Constitution for violation of the plaintiff's substantive due process rights and their procedural due process rights, as well as the violation of the North Carolina fruits of their own labor provision, that every person is entitled to receive the fruits of their own labor without arbitrary government intrusion. And that would be a claim that would apply and exist if their other claims did not. So it's our position that there can't be a scenario where there's neither a breach of contract or covenant and good faith fair dealing claim available, and there's also not a breach of the constitutional claim available, where you can't have neither, basically. That's the exact scenario that the quorum claim is designed to prevent when you have violations of constitutional rights like what occurred here. We allege, and our allegations must be taken as true in a Rule 12 motion like what we brought here. Another point important to consider, Your Honors, is there's no sovereign immunity here for breach of contract claims. That's clear in the Smith v. State case cited in our brief from the North Carolina Supreme Court, 289 NC 303, 1976 case. Good faith and fair dealing claims arise from a contractual relationship. There's also no sovereign immunity for claims against the state for good faith and fair dealing, just like there's not for breach of contract. The state steps into the shoes of any other litigant who's by entering into a contract with a private person, just like they did here. Now, before, as Your Honors are aware from your review of the record, before filing our complaint in this matter, the petitioners or the plaintiffs did bring a OAH proceeding that was limited to the mathematical calculations of the state's clawback and withholding of their benefits. And that hearing, it was significant for what was not decided, Your Honors. There was never any decision made in that hearing on whether plaintiffs had a valid and enforceable contract to receive disability benefits from the state. There was no decision made on whether there was a breach of that contract by the state by reducing the benefits. There was no decision made on whether there had been a breach of the implied covenant of good faith and fair dealing, and there was no decision made that on the constitutional issues, whether there had been a violation of any kind of constitutional right. None of those things were issues in the OAH proceeding. None of them were decided by the OAH court. And the administrative law judge who presided over that proceeding clearly stated that her role was limited to figuring out the mathematical calculation of the benefit reduction, whether there were any miscalculations in the documents and amounts. And the ALJ also stated expressly that she cannot rule on any constitutional issues, which is supported by the law. That's not within her authority to do so. And this is critical, Your Honor, because the one argument that has been advanced in the defendant's brief as to why they contend it was correct for the trial court to grant their Rule 12 motion to dismiss the Superior Court lawsuit is the doctrine of collateral estoppel. If you look at the defendant's brief, that is the one argument they make as to why the trial court was correct in granting their Rule 12 motion. That doctrine clearly doesn't apply. The doctrine of collateral estoppel requires, and I'm going to read a quote from the Bluebird Court v. Aubin case that we cited in our brief that just has the elements of collateral estoppel. That's 188 NC App 671 at page 678. And discretionary review was denied in that case. We cited in our brief. The elements of collateral estoppel require the defense to show all of the following. 1, a prior suit resulting in a final judgment on the merits. 2, identical issues involved, identical. 3, that the issue was actually litigated in the prior suit and necessary to the judgment, and 4, that the issue was actually determined. And they're clearly not present here. There were not identical issues with our claims in the Superior Court action for breach of contract, breach of the covenant of good faith and fair dealing, and violation of rights in the North Carolina Constitution. None of those claims were part of the OAH proceeding. None of them were before the ALJ. And because the issues in the Superior Court lawsuit are very different and they're not identical, then the doctrine of collateral estoppel does not apply. And it was error by the trial court to grant Rule 12 motion to dismiss on that basis. And there's an entirely other reason, Your Honors, very important, and we put this in our initial brief, why the doctrine of collateral estoppel does not apply here. And that is because the defendants who, in this case, they did not file an answer to our complaint in the Superior Court action. They instead filed a Rule 12 motion rather than answering the complaint. And the Rule 12 motion was based on Rule 12b1 and 12b6 of the North Carolina Rules of Civil Procedure, but that motion never raised the affirmative defense of collateral estoppel. And that is a procedural requirement to asserting that defense. The Court of Appeals has held, quote, collateral estoppel is an affirmative defense that must be pled. That is, close quote, the Fox v. Johnson case, 243 NC App 274 at page 279, cited in our brief 2015 case. And where an affirmative defense is raised for the first time in a motion to dismiss under Rule 12b6, the motion must ordinarily refer expressly to the affirmative defense relied upon. So they were required, it was a procedural requirement for them to actually plead either in their answer or in their motion to dismiss that they were basing their motion on the doctrine of collateral estoppel, which they did not do. So the doctrine doesn't apply, first of all, because the issues are not identical. But secondly, and separately, it doesn't apply because they never pled it. They never raised it in either their motion, and they never filed a responsive pleading that raised it. So that doctrine does not apply, and it was erroneous for the trial court to dismiss our claims on that basis, if that's the basis. And as I mentioned before, Your Honors, that is the only basis that has been briefed by the defendant as to why it was, they believe, correct for the trial court to grant the Rule 12 motion. The rest of their brief relates to the petition for judicial review of the OAH proceeding. And as I've mentioned, Your Honor, and we set out the standards in our brief, a Rule 12 motion to dismiss here for our Superior Court claims, the allegations in our claim, in our pleading, must be treated as true for purposes of deciding that motion. And when there's a Rule 12b1 and 12b6 in the same motion and they're based on immunity, then the factual allegations are treated as true for the Rule 12b1 motion as well. We set out that law in our brief, the Stone versus North Carolina Department of Labor case, 347 NC App 473 at 477, 1998 North Carolina Supreme Court case. So, Your Honors, we believe it was error for the trial court to not treat the complaint allegations as true, and we clearly allege that there was a contract, that there were rights of our clients to receive the benefits and not have them withheld in this way without due process based on incorrect calculations, and that there was a claim there. Our allegations were not treated as true. It's very clear looking at our complaint that we pled proper claims, and in the alternative, a quorum claim. And that was all thrown out without looking at the actual allegations in our complaint and treating them as true, which we believe was error. Now, on the, it is a separate issue that we have also appealed. The trial court's decision to deny, or excuse me, to deny our petition for judicial review of the OAH proceeding related to the mathematical calculations. And the denial of the petition for judicial review, I just want to make this point clear, Your Honors. That does not require dismissal of the Superior Court claims because the issues are different, the relief is different, and the doctrine of collateral estoppel does not apply. Just want to make sure that's clear. Denial of the petition for judicial review is different from dismissing on Rule 12 the Superior Court claims. But even though the petition for judicial review was different and not tied to the Rule 12 decision on the Superior Court claims, we've appealed that decision for a simple reason that the evidence was, we believe, clearly established before the administrative law judge that the mathematical calculations were erroneous. If you actually look at the financial records and the bank statements showing the amount of federal disability benefits received by Ms. Shuford, it does not match up with the amounts that were withheld, that the state used to add up to calculate the amount that was withheld under the formula I already described for Your Honor. So that's set out in our brief as well. I'm into my rebuttal time, but we believe that the record was clear that the calculations were incorrect. And so we also think that the petition for judicial review should have been allowed. That's different from the Rule 12 motion to dismiss, which we think was clear error to grant the Rule 12 motion to dismiss. So we respectfully ask that the Court of Appeals reverse and remand this matter to the trial court so that Ms. Moss and Ms. Shuford can finally begin litigating their claims that they haven't had a chance to litigate yet. I thank you very much. If there's no other questions, Your Honors, I'll save my remaining 3 minutes for rebuttal.
Thank you, Mr. Taylor. Ms. Murphy, you can proceed.
And I do prefer to stand. I think the camera is fine, but if you would rather, I can sit back down. Is this okay in terms of?
I think you're fine.
Okay, thank you, Your Honor. Good morning, and may it please the court. I'm Catherine Murphy, and I represent the Retirement Systems Division of the North Carolina Department of State Treasurer. I'd like to address 3 points today. The first being that because appellants have not shown that the ALJ's findings of facts are unsupported by the record, or that her conclusions of law were erroneous, the ALJ's decision was properly affirmed. Second, I want to argue that collateral estoppel does bar all the claims in the complaint, and therefore that motion was properly granted. The motion to dismiss pursuant to 12b-6 was properly granted. And third, the alternative basis, which the court granted, that a motion to dismiss is a 12b-1 motion, the constitutional claims are barred because there was an adequate state remedy. So the first point here is that the petitioners, now the appellants, had the burden of proof in the Office of Administrative Hearings to show that the calculations made by the retirement system were incorrect. And there were 3 allegations of error that were brought forward before this court, and we showed in the brief in some detail that in fact the record evidence showed that the calculations were correct. So the appellants had failed to show, based on the record, that there wasn't substantial evidence to support the findings. I think I will rest on the brief on that because those calculations are a bit involved. So, but I just want to say the calculation, Mr. Taylor misstated it a little bit. I just wanted to make sure it was clear. Under the statute 135-106B, the method of calculation of the benefits is laid out there. And it begins with 65% of the salary of the recipient prior to going out on short-term disability. So that's the unreduced state benefit is 65% of their salary. Then the statute, again, it's 135-106, subsection B, tells the retirement system to deduct an offset based on the amount of their Social Security disability award. And that's the amount that that the recipient is entitled to receive. And as I say, there was no evidence presented that would show that these calculations that were done by the retirement system were incorrect. I think the primary argument was on the basis of a net amount that was shown by Ms. Schuvert's bank statements, whereas under the statute, the amount that's subtracted, which is what was used by the retirement system, is the gross amount paid by Social Security. So that would account for the discrepancy that they highlighted in their brief. There's also an alleged error based on COLAs of the Social Security amount. The allegation was that there was an additional offset made in years where there was no COLA. In fact, if you look at the proper months, you'll see that the offsets were only made in the appropriate month. In the years where there was no COLA, there is no offset in the month when the COLA would have showed up. So I think I want to focus most of my time on my second point, which is the collateral estoppel argument. First, I want to say it is true, generally speaking, that under a 12b6 motion, the Superior Court is required to assume the facts pled in the complaint are true. But if the complaint on its face shows that a claim cannot be successful, then that trumps the sort of general rule that you should assume the facts are true. And I'm not saying this is what happened here, but for example, if a complainant were to allege certain facts and then allege contrary facts in another part of their complaint, well, obviously you can't assume they're all true if they contradict each other. In this case, they've alleged there was a contract and the contract was breached, but collateral estoppel can be read from the face of the complaint. The complaint was attached to the petition for judicial review. The petition for judicial review contained the final decisions of the ALJ, and the complaint expressly incorporated all of that into the complaint. So on the face of the complaint, you can see both an allegation that there was a contract that was breached and the necessary elements of collateral estoppel showing that the contract wasn't breached. And so therefore, I think you have to the judge, the Superior Court judge was correct.
Now, Ms. Murphy, I have a question. You do not contend that you in fact raised the issue of collateral estoppel at trial, do you?
No, it was not in the motion to dismiss. It's true, we did not file an answer. It was not in the motion to dismiss. But if you look at the case that the appellants are relying on, Fox versus Johnson, only part of the quote was quoted, and I'd like to read you the whole quote. After saying that an affirmative defense should be raised in a motion, it says, however, and I'm quoting from the court, however, where the non-movement has not been surprised and has full opportunity to argue and present evidence on the affirmative defense, the failure of the motion to expressly refer to the affirmative defense will not bar consideration of the defense by the trial court. So in this case, of course, it's not in the record, but we did have a briefing schedule. So briefs were filed arguing collateral estoppel. Briefs were filed arguing against collateral estoppel. Then there was argument in the Superior Court. And as I say, the collateral estoppel is clear from the face of the complaint. So it's not like there was extraneous evidence that was brought in that caught the appellants by surprise. So I think even Fox versus Johnson, if you look at the full opinion, makes clear that you can consider collateral estoppel, that the Superior Court properly considered collateral estoppel as well. Now the collateral estoppel is issue preclusion. So we're not saying that the contract claim per se is barred. We're arguing that there's a factual predicate to proving the breach of contract that cannot be relitigated. In other words, in order for the appellants to argue a breach of contract, they would have to show that the calculations were incorrect. There can't be a breach of contract if the calculations are all correct, but they can't relitigate that. They've already had their opportunity to litigate whether those calculations are correct or not, and they were unsuccessful. So the breach of contract claim cannot move forward because they can't prove that the contract was breached. Now the contract, just to be a little bit clearer about that, and I think the think the appellants are in agreement with this. The contract itself is determined by the statutes that were in place at the time of vesting. The statutes regarding how the calculations are made really haven't changed in any significant way from the time the statute was enacted. I mean, the DIPNIC, the Disability Income Program in North Carolina, was enacted, I believe, in 1988. These appellants became disabled in 89, 91. And it's not changed in any real significant way. So the way their benefits are calculated is determined by the statute. Whatever they vested in determines how that's calculated, and it hasn't really changed except in one minor respect that we addressed in the brief in terms of when the offset for Social Security is changed due to the COLA. The other significant piece of their contractual rights is North Carolina General Statute, Section 135-9, subsection B, which is the section that authorizes the Retirement Systems Division to recoup an overpayment through withholding amounts from ongoing benefits. And that particular provision was enacted by the legislature in July 1985. So in order for the plaintiffs, well, the plaintiffs vested, our position is that they never vested. But if they had vested, they certainly vested after that statute was enacted. So that statute is part of their contracts. In other words, their contract rights were, you get disability benefits calculated in this respect. If you receive an overpayment, then the division may recoup the overpayment through withholding pursuant to this other statutory section. So if the calculations are correct, there is an overpayment. We know the division is authorized to recollect it through these withholdings. There's no breach of contract. And for the same reason, there's no violation of constitutional rights, because the appellants received more than they were entitled to receive. And now the Retirement Systems Division is simply taking back the monies that petitioners received that they were not entitled to receive in the first place. So it's not the breach of contract that we're saying is barred by collateral estoppel. It's a predicate fact you would need to prove that's barred by collateral estoppel. And we laid out in the brief how each of the components of collateral estoppel are met. It was a final decision, being an OAH, which is the trial court for the purpose of an administrative proceeding. It was the same parties. And that issue about whether these calculations were correct is the issue we're saying they're stopped from relitigating. So they won't be able to successfully litigate a breach of contract claim or these constitutional claims, and therefore it's proper to dismiss on the basis of 12b-6. I would like to just point you to McCallum. The McCallum case, it's at 142 North Carolina App 48. It's cited in plaintiff's brief, an appellant's brief, and I think it's a good illustration of this idea that this is barring a factual issue. Collateral estoppel applies to a factual issue, not the claims. The claims don't have to be the same in order for collateral estoppel to apply. And in the McCallum case, which, as I say, was cited by appellants, the plaintiff brought a discrimination lawsuit after he was dismissed from his employment. He claimed that he had been discriminated on the basis of his race and that he had been dismissed for in a retaliatory discharge. He filed first claims in federal court. Well, they filed it in state court. It was removed to federal court, alleging various violations of the federal constitution. A federal court found that there was no evidence of intentional discrimination and that he failed to provide sufficient evidence that there was a retaliatory motive in his dismissal, and the case was dismissed. The plaintiff then filed in state court alleging violations of the state constitution, and he argued collateral estoppel can't apply here because federal claims are adjudicated differently from state constitutional claims, that these that only a state court can properly interpret the state constitution, and this is a new claim. And this court held that even if those are different claims, there's a factual predicate which is the same in both, and that is he was going to have to prove in state court that he was discriminated against, intentional discrimination on the basis of his race, and that a motivation for firing him was his protected activity. And this court held, you've already done that in federal court, you've lost, that's collaterally stopping you from relitigating those claims. So I think that provides a good example analogous to what we have here, where the claims are different, but there's a factual predicate that is the same in both. And if you've already litigated it and lost in one forum, you can't litigate it again in a second forum. The third thing I wanted to address was the constitutional claims, the alternative basis for dismissing the constitutional claims, which is the adequate state remedy. And we've cited two cases in the brief for appellee, Hawkins versus State and Hubbard versus North Carolina State University. Hawkins versus State, a technician who worked for the Western Carolina Center was dismissed. Drugs had gone missing. He was asked to take to provide a urine sample for a drug test, and he refused. He was dismissed. He filed a petition in OAH under Chapter 126, which is the employment statute, and he was unsuccessful. He tried to get his position back. He argued there was no just cause. He was unsuccessful. He then filed a complaint in Superior Court, and he alleged various claims, including a violation of his due process rights under the state constitution. And this court dismissed the state constitutional claim, holding that this administrative remedy in OAH was an adequate state remedy. So the fact, again, that these are different, there's an administrative process and there's a constitutional claim, they're different claims, but the idea is that you can have your harms addressed through the administrative remedy. That is an adequate state remedy. Just because you're now asserting something a little different under the Constitution doesn't mean you have the right to proceed under the state constitution. The OAH proceeding is sufficient. In Hubbard versus North Carolina State University, again cited in appellee's brief, the plaintiff was an employee of the university. He reportedly, he reported what he alleged was misconduct of a supervisor. He was later dismissed. He claimed that he filed claims for a whistleblower, a violation of the Whistleblower Act under state law. And he also filed a claim under the state constitution for a violation of his free speech rights. The Superior Court granted granted summary judgment on both those claims, and on appeal to this court affirmed summary judgment on the Whistleblower Act, and at the same time said, even though we're affirming summary judgment and he was unsuccessful in his state law claim, we still find that that was an adequate state remedy, and therefore we're also dismissing the constitutional claim. So I think that covers pretty much what's going on here. We have the plaintiffs, petitioners, appellants brought their OAH proceeding. That's a sufficient state remedy. That is a place where they can address their harms. They had the opportunity to argue to the administrative law judge that the state wasn't paying them what they were entitled to receive, that the state was improperly withholding benefits to make up the overpayment. They had the opportunity to argue it. That's an adequate state remedy under Hawkins. And then the fact that they've done that and they were unsuccessful does not make it no longer adequate under the Hubbard case. The fact that they did it and were unsuccessful, they had the opportunity, that's the important thing. And so I think unless there are other questions, I still have time, but I believe I've made the points that I wanted to make.
Any further questions?
I'm sorry, Your Honor, I did realize this.
Okay.
My notes. I did want to address the issue of the statute being amended. I believe Judge Carpenter asked Mr. Taylor, do you agree that the that the contract rights are determined by the statute. And Mr. Taylor said, well, by the statute at the time they vested, but the statute has been amended. And I wanted to say the statute has not been amended in any way that would affect the results since the time whenever they may or may not have vested. And so I just wanted to make sure that was clear. I think we both agree, we both cited the Wells case in our briefs, that whatever contractual rights they have are determined by the statutes, and the statutes that were in place when these women both became disabled, went on short-term disability, went on long-term disability up until the time that the recoupment started. They have not changed in a way that would change the result in this case. And so we would ask that the court affirm the Superior Court judge's both orders, both affirming the ALJ's final decisions as well as affirming the Superior Court's order that dismissed all the claims based on 12B1 and all the claims based on 12B6 and the constitutional claims based on 12B1. Thank you.
Thank you, Ms. Murphy. Mr. Taylor, you may proceed with your rebuttal.
Yes. Thank you, Your Honor. Can you hear me okay? Thank you. I would, just to follow that last point, respectfully disagree. I think there was a significant amendment to the statute that allowed for a basically unlimited period of time for a clawback. It was also raised in the briefing in the Trejo case. So that, I think that was a significant amendment. There have been other amendments to the statute, but there were amendments on the duration of the clawback and allowing this type of thing to occur that we think the rights vested earlier to that point. So I would just respectfully disagree with that characterization. I do want to respond to the points made about the Fox versus Johnson case and the requirement that collateral estoppel as an affirmative defense must be pled and asserted specifically in a motion to dismiss. We correctly cited the Fox versus Johnson case, and the quote actually came from a quote of that court in a prior case involving the same parties. The Fox case, if you read the opinion, Your Honors, quoted a earlier Fox case where the parties, the defense had initially not properly raised the affirmative defense of collateral estoppel, and there's some discussion on that. There was that motion to dismiss was denied by the trial court. The defense tried to appeal that, and the appeal was dismissed as an interlocutory appeal. And then later, the defense actually filed an answer that asserted specific factual support for their affirmative defense of collateral estoppel. And then the case was brought up again for a second round at the Court of Appeals. And that's the 243 NC App 274 case from 2015 is the second trip to the Court of Appeals. And in that case, the court did consider the merits of the doctrine of collateral estoppel and rejected it again. And I believe that the Fox case is very instructive on both the procedure of that point and just the merits of that issue, which I believe even if the court were to consider the merits of the issue here, it was error by the trial court to dismiss the claim based on collateral estoppel because the issues are so different. You have to have identical issues between the administrative court, the other court, and the subsequent Superior Court action, and they're not identical. So collateral estoppel wouldn't apply even if that issue was properly before the court. Thank you.
Are there any further questions? All right. Thank you, Mr. Taylor.
Thank you.
That concludes oral argument in this matter. Thank you, counsel, for your excellent arguments today.
Thank you, Your Honors.
Thank you very much, Your Honors.
This session of the North Carolina Court of Appeals is adjourned.
Have a good day. It was good seeing you.